Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna PC. Today is October 3rd, 2019. This is our bi-weekly, every 2 weeks, community conference call in which we try to answer the questions raised by the community in posting through our forums. As you would have heard when you entered the conference, that this is not a substitute for a one-on-one in-depth consultation. We can give you a general direction, but at best we can only answer generically what we believe your questions are. That said, let's begin. I'm going to go over first the frequently asked questions. I have marked certain questions as frequently asked because I think they come up quite a lot. And then we will go over all the other questions that are not frequently asked. If we still have time, we might take up new questions, but it depends. I doubt that we'll have time today because we have enough to cover an hour. The first frequently asked question is, it relates to when should we file, excuse me, when should we file supplement J for AC-21? So once your 485 has been pending 180 days and I-140 is approved, you can change jobs to same or similar job anywhere in the country. But you have to inform the government at some point that you have actually changed the job. There's no law that says that you've got to file it every time you change jobs in this manner. But there are pros and cons to filing and not filing early. In most cases, I prefer to file early for two reasons. One reason is that having filed the supplement J, in a few months you know whether it's going to get approved or not. So you actually get an approval notice that supplement J has been approved. In other words, government has compared the two jobs and they believe them to be sufficiently similar, so you're good to go. Number two, so it gives them enough time to work on it and you're not doing it at the last moment. Number two, there are certain legal rights that are available to you when you have declared your AC-21 intent. That is not to say that if you haven't filed it, you are not covered by the benefit of AC-21 laws. AC-21, American Competitiveness in the 21st Century Act, is the law that for the first time gave us the proposition that you can change jobs like this. So we are covered by AC-21 laws. I think that if you file the supplement J, you have a little bit better protection under the AC-21 laws. So if you ever end up going to court, you are better protected than if you have not filed. And of course, you could always file just before you go to court. The reason not to file an AC-21 early would only be if I don't know how long I'm going to remain at this job. So if one of our clients calls us and says, Rajiv, I am going to be doing this project only for 6 months and I don't know where I'm going to go after that, I would probably not file an AC-21 for them. For the simple reason that I don't want to keep filing. There's no limit to how many supplement J AC-21 you can file. You can, each time you change a job, you can file another supplement J. But that's recurring expense, and I think that's unnecessary. If I know that you're going to be at this job for a longer period of time, I would want to file supplement J and file it early. I don't think you should wait. Okay. Anybody has a follow-up question, press *5 only on this issue, supplement J. If you have a follow-up question, press *5. Okay. Let's move on to the next frequently asked question. Hang on one second. I just forgot to read the question. So the question in response to which I covered this topic, I'm waiting for my green card with a PD March 2010, more than 180 days, moved to the same job. Can I file closer to the day when I receive the green card? Or is it recommended that I file as soon as possible? So yeah, I think I covered those two issues. Let's move on to the next frequently asked question. changing employers after 180 days of I-140 approval. So first of all, just to give you a quick rundown, and I've covered this many times in our frequently asked questions, which you can find on our website, immigration.com. The frequently asked questions, actually many times they are repeated simply because I may have added one or two extra things each time I talked about it. So under the regulations that became effective on January 17th, 2017, if your I-140 gets approved, the moment it gets approved, the priority date becomes yours to keep even if you change employers and even if the employer revokes your I-140. The only thing you lose is if the revocation occurs before 180 days of approval, you lose your ability to extend H1 beyond 6 years based upon that particular I-140. If on the other hand, I-140 is approved, priority date is yours to keep, it stays approved for 180 days. Now, in addition to the priority date, you have the right to keep extending your H1 beyond 6 years based upon that approved I-140, even if it is later withdrawn by the employer. So that's a very big advantage. And not only that, if your wife had obtained or your husband had obtained an H4 EAD based upon that I-140, after 180 days, even that right of your spouse to extend the H4 EAD based upon a withdrawn or revoked I-140 can still go on, no problem. The only time you have an issue is if the I-140 is revoked for an erroneous approval by USCIS or for some fraud or misrepresentation. Now, the question from Kumar is, what happens in the worst case if I move to a new employer and my new perm I-140 is denied? And the answer is based upon what I just discussed, because you have a fallback position to keep extending your H1 based upon the old I-140, I don't see what you have to worry about. Your priority date is secure. Your future extensions are secure. You can just refile the perm if the perm through the new employer is denied. I don't see any problem. I can't see any worst case scenario. Anybody has a follow-up question on this issue, press *5, please. Okay. Next frequently asked question. This is also a very commonly asked question. So if let's say I'm a programmer, when I started my green card, it was filed as a programmer, but the green card has been pending now for 17 years. And now I have taken several promotions, and by now I am a systems manager, or let's say I'm, I don't know, a chief technology officer. Can I still file my 485 when the dates become current for the programmer position, which is like 70 years below me by now? And the answer is theoretically yes, but practically no. Theoretically yes, because if I can, in good faith, under penalty of perjury, say that I would be willing to take that job, the programmer job, on an indefinite basis if you get my green card approved, I can file it. I can file the 485. But if I cannot in good faith promise that I intend to and keep that programmer job forever and ever and ever, then you shouldn't be filing an I-485. Okay. So as a theoretical matter, you could do it. As a practical matter, it hardly seems advisable. I think the better option would be to start a new green card for the position, the advanced position that you are now holding. Actually, that is your case, Computer and Information Systems Manager. Earlier was software developer. So you should just start a new green card for software developer, for systems manager, and transfer the priority dates. What is the problem with that? That's what makes the most sense. I would not advise filing for a much lower position. I think it's counter common sense. *5, Ashika, if you have a question, I think I see you on the online. Uh, if you have a follow-up question, press *5 on your phone. Okay. We have an Asha on the line. I thought it was the same person. Okay. Let's go on to the next question, next frequently asked question. Expediting H4 EAD. This is a painful problem for many people. What some lawyers are doing is they are collecting cases like 10, 12, 13 cases and filing together in one case, in one complaint to the court for expediting. And what the government is doing is, as soon as the cases are filed, within a couple of months, they are approving the pending H4 EADs. So there's definitely that option. My own experience with expediting cases, we had a case filed 2 weeks ago. Yeah, I think it was filed, I think September, third week of September. So third week of September, I filed a lawsuit against the government for expediting a naturalization case. And in 2 weeks, the government called me back, said they were ready to approve my, or not to approve, sorry, to adjudicate my case within 30 days if I would agree to withdraw the complaint. So it appears that courts are effective. I haven't yet filed any case for H4 EAD expedites. Lawsuits are expensive. They can get expensive because if the government doesn't fight you back, lawsuits are just like filing an H1B. But if the government fights you back, it can get expensive. So we have to be careful before we file a lawsuit. And of course, if you got 7, 8 people in the same lawsuit, then they can split the expenses. Then it's not expensive at all. Okay, so lawsuit is an option. But before you go there, one of the things you can do is, if you Google USCIS expedite criteria. So if in a search engine type USCIS expedite criteria, and I think you'll see 6 or 7 of them. One of them is of financial loss to you and or to your company. So you can make a request for expedite based upon the fact that you are going to lose your job if they do not approve your H4 EAD in time. Are they bound to expedite? No, but they might be able to. We've had some success, and when I think we have done 1 or 2 expedites, but I recommended this method to many people, and it appears that has worked out well for them. So before thinking of a lawsuit, try filing an expedite, and at the same time, contact your local congressman's office and see if they can intercede on your behalf to get you an expedite. If that works, wonderful. Then you have nothing to worry about. If that does not work, then definitely you can examine the idea of filing a lawsuit. Okay. *5 if you have a follow-up question. *5. Okay, no follow-up question on this. Another interesting question: is there a correlation between processing times and priority dates? I'm not sure of our current attendees how many are familiar with this issue. So let's say you filed your green card, you are a US citizen, you filed a green card for your spouse or your parents, which are considered to be immediate relatives, and there are no waiting times for them. They are not subject to any priority date movement. However, it still takes them about a year, year and a half to get here. Why? That's because the processing time, the time it takes the government to move the paper from approval by the USCIS, compilation of the file by the National Visa Center in New Hampshire, and finally moving the file to your home country, and then organizing details like medicals, an interview, etc., itself can take about a year, year and a half. So even though there is no waiting because of priority date movement, there is definitely waiting because of processing time. So the relationship between processing time and priority date is as follows. They are both two different things. Priority dates are a backup built into the system because there are too many applicants in that category from the country where you are born. So if you are India born and you have filed as a spouse of a green card holder, or rephrase that, if you have filed for your spouse and you are a green card holder, there's a priority date backup. Whatever time you have to wait because of that is accounted for by the priority dates. The year and a half that it takes to get the file moving gets consumed within that time if the time is more than 1.5 years. So let's take two hypotheticals. One hypothetical is that the priority dates are backed up 2 years and the processing time is 1.5 years. That means once you file the case, it takes a year and a half for the case to go through to India or wherever you are from, and you still have to wait another 6 months for the interview. Why? Because the priority dates are backed up 2 years. So when the priority dates are that far backed up, more than the processing time, it doesn't really delay your case. Let's take another example. This time, same two people, but the backup in the priority date is 1 year. Here, because of the 1.5 year processing time, even though the priority dates moved fairly quickly, you had to wait an extra 6 months. Priority date was backed up 1 year, but the processing time is 1.5 years. So that's the relationship between the two. Priority date is the backup which develops because of too many applicants in your category from your country, and processing time is what it takes for the government to move paper from status 1 to status 2 or location 1 to location 2. Star 5 if you have a follow-up question on this. Star 5. Okay, let's move on to the next frequently asked question. I think that is, oh no, there's another one. So this is also an interesting issue. Traveling while H4 EAD extension is pending. There's a difference between traveling when you have an extension pending and traveling when you have a change of status pending. So when you have a change of status pending along with your application, for example, F1 to H4, you are asking for H4 at the same time you're asking for a change of status. If you travel before the change of status is approved, your application is deemed to be abandoned. If on the other hand you're just filing an H4 extension and filing an EAD with it, that is not a problem. If you travel, as long as you have a visa stamp, you can come back, and as long as you come back within the time of your visa. Okay. Government has said that your EAD can get delayed if you travel. As a practical matter, I have seen no evidence of it. Already the H4 EADs are getting delayed so much, I don't think a travel is going to hurt you. So exactly the question is, I'm on H1B, wife is on H4 EAD, good till 2020. We are planning to apply for her H4 EAD together, but we are traveling in the second week of December, coming back in first week of January. Would there be any risk on H4 or H4E extension? There's no risk other than a potential for delay according to the government, of which I have seen no evidence. Can it lead to denial or RFE? No. Just because of the travel, I don't see why that's the ground for denial or RFE. Do we need to go for stamping? Yes, because if you don't have an H4 stamp, you can't come back. Star 5 if you have a follow-up question. Star 5 if you have a follow-up question. Okay. So these were the frequently asked questions. Now let's go to the regular non-frequently asked questions. This is question number 3. Star 27 says, do we get 60 days of grace period after leaving an employer and before joining another employer? Assuming you're talking about H1B, the answer is yes. You do get actually the shorter of the 60 days or the time remaining on your I-94. So if your time remaining on the I-94 is 31 days and you are changing employers, you don't have 60 days, you have 31 days. So whichever is shorter, the duration of left on your I-94 or the 60-day grace period that has been decided.
One moment.
1 second. These intelligent assistants come on without me asking for it. Okay, so once again, 60 days or the time remaining on the I-94 is what you get. Now, but here is the weird part, which is a very good question. What if the old employer has revoked the H1B? So if they have revoked the H1B, technically you will have lesser time on your I-94 because the I-94 is gone upon revocation. I have argued with the government and I think we were successful. I don't remember the details of the case. Just I think last year we argued that if you were to cancel off the 60 days grace period just because the old employer revoked the H1, then you are basically nullifying the entire case. Because think about it this way, it is the law, as soon as an H1 employee leaves or is relieved of his job, you are required, the employer is required to inform the government. Okay. If the moment the employer informs the government and the government acts on it, the EAD is gone. So that means every time the H1 employment is severed, government has to be informed. That means I-94 would be revoked. So the very idea of a regulation always being less than 60 or almost always being less than 60 days doesn't make sense. So our contention with the government was that revocation does not affect the I-94. It worked in that case. I don't know if it will work again. This government has not given us a firm policy on this issue. Star 5 if you have a follow-up question on this. Star 5. Okay. Question number 4. 2019 fiscal year, my H1B got denied because my OPT, they said my OPT, I was unemployed for more than 90 days. Okay. There was some conflict with the dates, and the argument is that USCIS has misunderstood the case because you did work, but you worked without pay. And that's allowed on the initial OPT, not on the STEM OPT extension, where you have to work getting remunerated, but you don't have to be paid while you are on the first year of OPT. USC has mentioned the denial notice that you have to leave. Presently, I've enrolled in the PhD course. DSO has confirmed my service is active. Can I continue to stay in the US? And the answer is no. Once they have made a finding that you are out of status, your unlawful presence begins. So if you are unlawfully present for 180 days past that finding, government will say that you are subject to 3-year bar. If you continue to stay more than 1 year after that finding of violation of status is made, you become subject to a 10-year bar. So no, just because your service still appears to be active and you are enrolled in a PhD program, I don't think you have sufficient protection. So I would definitely want to speak with your lawyers and make sure that you do the right thing, whether it's leaving or I don't know how many months or years you've been quote unquote out of status or unlawfully present, but that's a decision you have to make with your lawyers. Star 5 if you have a follow-up question. Star 5. Okay. So this Mama Jack is a retired military veteran, and we thank you for your service, who, despite making it clear that I am retired, has been bugged by the NVC, the National Visa Center, requesting pay stubs. Could you explain why? And the answer is government copies and pastes information. They don't really many times look at the case. So, this is what I would recommend. I know that American Immigration Lawyers Association has a program where a lot of the lawyers are participating to help servicemen and women, of course, pro bono without any charge as best as they can. But I think what would be more effective if you just contact your congressman's office and you tell them, why is NVC jerking me around? They should be able to fix it in a day or two. I don't think this is going to be such a big issue. To me, it looks more like a copy and paste problem. They applied something to your case which clearly doesn't apply. Star 5 if you have a follow-up question. Ashika says, this is, I believe, I had another question from the same individual. Okay. She says, I hear that one has to file I-485 within a year of the dates getting current. There is no law that requires that. I think there is something in the law about extensions of H1B. And I don't remember off the top of my head what that regulation is, because we've never had to face that situation. But theoretically, at least, leaving aside the H1 issue, then let's say practically or really, there's no limit to how long you can wait to file I-485. So the I-140, once approved, is good forever as long as the job is in existence and your desire to join is in existence. So there's really no limit, not from the green card perspective. You should be able to file your 485 whenever you're ready. I don't know, file it with your new employer? I don't know about that. It says, oh, I see you are filing a new green card through the new employer. Yeah, I don't see any problem with that at all. You are not confined to any particular time frame. If you are starting a new green card, you will inherit its priority date even if you file the case 10 years down the line. Star 5 if you have a follow-up question. Star 5. Okay. Moving on to the next non-frequently asked question, which is question number 11. So here we have a situation where a US citizen wants to sponsor 3 married children and their families. Income is not sufficient to sponsor them. One joint sponsor whose income is enough to sponsor each family, but not all 3 of them together. So this is a little complicated. One of the things that government can look at is the assets of the people who are coming in. So the people that you are sponsoring, their assets, especially if they can be converted to cash within a year fairly quickly, their assets can be counted towards public charge issue as well. I cannot predict if you are going to have a problem at the consulate level, but you can prepare for it in the manner that I suggested. Get together with a lawyer and go over and see if you can use the assets of the people that you have petitioned for as part of the equation. And another obvious answer is to get more than one joint sponsor. Star 5 if you have a follow-up question. Star 5. Okay. Question number 12 says, new public charge rule. I'm a US citizen. And by the way, I have reviewed some part of the rules as I had indicated last time when we spoke. But we are very, very busy because all these unprecedented number of RFEs also on the green card side. It was previously only on the H1B side. So, but I did review some of the issues have become clear to me. And by the way, government has issued some corrections, I think yesterday, which are still to be incorporated in the final regulations. So I'll create a page and I'll take it from there. But if there's somebody with public charge issues, I can at least answer some basic questions. You said your parents are coming in on a visitor visa. I want to apply for their green card. Stop right there. Nobody should enter USA with a preconceived intention to obtain a green card, because they can consider that to be fraud. If, on the other hand, if somebody enters USA and after 3-4 months they develop the intention to stay, that can be okay. Sorry about that. So first of all, you have an issue with the entrance. Do not enter if you have a preconceived intention to apply for a green card. Okay. Now, as far as the public charge issue is concerned, you said you want to understand the public charge rule in detail. I think it's like 800 pages. I don't know if you can understand it in detail. That would be, even I don't understand in detail. I have read for some parts of it, but it's just too much information to absorb. I kind of understand the outline of the rule, how it works, to whom it applies, but it's not something I would say you can acquire in-depth information on, unless you're willing to spend hours upon hours on it. I can understand if the public charge rule makes you leery because it's coming in effect middle of October. I'm wondering, when did they enter USA? So if they entered more than 90 days ago, your application might be justified. And remember, you can file your I-130 and request consular processing, so that even if they enter USA now and you have applied for consular processing, then that rule against change of mind, etc., does not apply. So if they entered more than 3 months ago, I think you are fairly safe to file for their green card and adjustment of status, and you would not be affected by the new rule. Or you can apply, if they entered less than 90 days ago, you can apply through consular processing, and I don't think that's a problem either. *5 if you have a follow-up question. *5. Okay. Next question, number 13. Somebody tried to refile an N400, but the old one is still pending. The answer is yes, it makes sense to write to the USCIS to withdraw the N400. One of my colleagues pointed out to me the other day, and I think they're right, that you don't have the absolute right to withdraw the N400. Although as a matter of practice, government has never stopped us from doing it. But technically they could decline. I think they can decline that from pretty much any application if they so choose, based upon one ground or another. So N400 withdrawal is not a right, but I don't see it as a problem. So if you have an earlier application pending, of course they're not going to accept a new application on the same case. So please go ahead and withdraw the old application. What do? You do two things. First thing you do is you contact the customer service. You tell them you want to withdraw. They'll probably take a note of that, and then they'll ask you to send in a letter. It may even be a notarized letter. So go ahead and do those two things. *5 if you have follow-up questions. *5. Okay. Arminder says, wife is working on H1B from October 2011. Last extension is approved till 2020. I-140 is also approved. She left USA in 2018, but she's working remotely, planning to return back and continue working for the same employer. So she's coming back a few months before 2020 December, when her status is expiring. I want to check how she can get her H1B extension or H1B visa status back in USA. Does she need to claim her H1B from September 2018, 2020 and file as an extension? Well, why are you getting into all these details? This is for your lawyers to figure out what is the best way to do it. She's entitled to a 3-year extension based upon the I-140 approval. Whether the application is filed as an extension from inside USA, outside USA, depending upon her circumstances, is equally okay. It can be done. Can a person file for an H1B extension from outside USA? Not really an extension, but it's an H1B approval, which then goes to the consulate for a visa stamping. So this is just nomenclature. Don't get bogged down by that. It's not that important. What is important is that it can be done. Okay. Star 5, if you have a follow-up question on this, star 5. Okay. AP Desai says, my wife and I are both currently working on H1B beyond 6 years, I-140 approved in EB2. Both are employed with respective employers 10 plus years. There's a 5-year-old daughter. Wife is currently traveling 135 miles round trip each day. Wow. Her manager was changed 2 years back, and they're not letting her work from home. So my EB2 date is 2010, hers is 2012. Is it possible for her to apply for dependent EAD? Well, you mean H4 EAD, right? I think there might be another option. Because her I-140 is approved, you can also look at, I don't know what they call it, exceptional circumstances EAD. She can get an EAD based upon exceptional circumstances. I keep trying to remember what my blog has an entry on that. We've done a few of these cases. They were all approved. So you can simultaneously file for her H4 and H4 EAD as well as an EAD based upon the fact that she's undergoing this 130-mile trip with no respite with a 5-year child at home, and she would want an EAD based upon her I-140 approval. So that means even though she has not filed her 485, based upon her I-140, with the priority dates backed up, she can actually apply for an employment authorization. Only danger is, and I don't think it's much of a danger in this case, that she is then considered to be in authorized period of stay. If she wants to convert back to H1, she'll be required to step outside USA for visa stamping after the H1 approval. I don't see it as a big problem. And the only problem is if you apply for her H4 EAD, what is happening these days is the H4 gets approved first. The moment the H4 gets approved, she has to stop working. And once she stops working, then she has to wait until her EAD is approved, which can take several months. Can she quit her job and look for another? Well, even if she converted to H4, easiest thing would be step outside USA, get an H4 visa stamping from any consulate like Mexico, Canada, Jamaica, come back in, start looking for another job, and as soon as you find a job, apply for H1 premium processing. You can't start working on H1B again until the H1B is approved. But you do not have to go through the lottery again. I don't see any problem with porting the priority date even if there's a break. That's not a problem at all. Star 5, if you have a follow-up question on this, press star 5. Okay. Next question, number 16, is I'm currently on my EB1A. Went for interview of the 485, got my EAD-AP, good for 1.5 years. Can I quit my job and start my own startup? And the answer is yes. Theoretically, at least. See, it doesn't matter if the EB1A case is submitted by a lawyer hired by the employer. And I don't see how they can ruin your case. Only thing I would want to do is I want to have your lawyers take a look at your application and make sure that you will continue working in your own field of expertise. So let's say that you have a degree from Harvard or MIT, and you have a PhD in Internet of Things, IoT, and that's how your EB1A was filed as an expert in IoT. Now you want to start your own company. As long as it is working in IoT, I don't see any problem. Okay. Star 5, and oh, by the way, and you can have multiple green card categories. If you apply through your US citizen spouse as well as EB1A, you can have as many applications filed as you like. You'll only get, you can choose to keep the one that you get the earliest. Star 5 if you have a follow-up question on this. Okay. The last question today is, I have a question from a friend. She was born in India and has an Indian passport. She got married in Nepal and now she has a Nepalese passport as well. Oh, I don't know anything about the OCI cards. We don't work on that side of the border or that side of the continent, I would say. Not even continent. We don't work in India. We work only in USA. Okay. I have no idea, Mr. Kumar, how that works. That appears to be all the questions. I still have 5-10 minutes. Anybody has any questions can press star 5 on your phone. Press star 5. Anyone has any questions? Okay. It looks like we are done for today. Thank you everyone for joining. We'll see you again in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.